Hey, I'm Sean Holyfield, CEO and founder of HR Law Made Easy. Today, I'm going to talk a little bit about the laws in the US, the employment laws, labor laws in the US, and how those break out into the required things that your business or businesses need to do, as well as some of the consequences of not doing those required things. And also, really importantly, the optional things that you as a business can do to protect you from lawsuits. So let's dive in and let's just get going. In the United States, there are over 1.5 million labor laws or employment laws. It's a lot. Those laws are created at a federal, state, and local level. And the types of laws that exist, or the words that are used to describe those laws, are mostly codes, regs or regulations, agency guidance, that would be publications and other things that are issued by the Department of Labor, as well as court cases. And we'll spend some time talking about court cases. When we look at these laws and we dive into and we read all of these laws, what you find is that for the codes, regs, and agency guidance, these are mostly the laws that tell your business what you're required to do. And it's a really important distinction. The reason being is that these codes, regs, and agency guidance, the Department of Labor or the whatever the government agency is that is creating the rules, they also write the regulations typically. So what they're doing is they're providing guidance on the things that you've got to do as a business. And those things break into 6 buckets. It's a nice thing is that there's actually like a finite universe of this, right? It's policies or rules that you've got to write down and get your team or your employees to acknowledge. Normally, those are delivered in the form of an employee handbook, but they don't have to be. All that really matters is that your employees read, understood, and acknowledged the policy in many cases. There are procedures that you may have to follow, specific things that you need to do in a specific order, documents that you've got to provide to your employees, which might include certain forms they've got to fill out and sign, agreements, that would be employment agreements and other things. Sometimes those are required and have to be signed. Notices and posters. Many of you know that there's these posters that you either get as a business from your local government, or you'll go online and buy these, but they're also available digitally, I know through our platform. And employees are required to view and or in some cases acknowledge that they understood those. And then you've got training. And training is most often optional, but there's lots of training that could be done to satisfy either legal requirements that are listed out in the regs or codes, or just simply training that's a good idea. Now, that's the way that the laws kind of feed into the required stuff. And again, it's mostly codes, regs, and agency guidance. Most of the state websites have got really good publications or other information that you can read. It's a lot to read, but nevertheless, these 3 pieces of information right here, these 3 types of laws, the codes, the regs, and the agency guidance, they're going to really give you the required things and stuff, which is what I like to call it, which is just this list that your company or your business has to do in order to be compliant with or follow the HR laws. It's a lot to read, it's a lot to get through, but nevertheless, that information is pretty straightforward. So what really trips up businesses and what I want to spend most of my time talking about is court cases. And it's not the cases themselves, it's how the legal system works in the US. So we have codes, regs, and agency guidance. They've told us the things that we're required to do. So we now know that we're either doing the things that we're supposed to do or we're not doing the things that we're supposed to do. But interestingly, court cases, they are where an employee and an employer go if there's a conflict. And this is where the courts look at these requirements and evaluate, look at whether or not you did the required things. But what they do is they also look at things that aren't required. And these are like the facts and circumstances. These are the unique things about your business. It could be additional things that your business does that other businesses don't do. It could be just things that other businesses have done that you've never met that the court knows about. And understanding what other businesses are doing, even though it's not required, they can use and do use that information to look at your company and make decisions based on what the employee and their lawyer has brought to the table. So let's talk about some of these common lawsuits and how the required stuff doesn't always protect your business. So with these court cases, and we'll talk about these first 3 together. Discrimination, which is simply making a decision on hiring, firing, or some other decision that impacts an employee, and the decision that's made is based on their protected class. So it's actually a negative or adverse decision, something not great for the employee. It could be that they were passed over for a promotion. It could be that they were fired. It could be that you didn't hire someone. And that decision was made based on their membership in a protected group or their personal characteristics. And there's a long list of these in the law. Things like a person that's over the age of 40, things like a person's gender or sex or sexual orientation. These are all protected characteristics and or things that are protected by the law. And you're not allowed to make an adverse or negative business decision based on that fact. Sure, you can have somebody that's over the age of 40 and you can choose not to promote them, but you're not allowed to make the decision based on the fact that they're over the age of 40. That's discrimination. Retaliation is where somebody speaks up at work and says, hey, I've noticed something that's illegal or something that's not right. And then the business decides to take an adverse or negative action against that employee because they spoke up. That's retaliation. You're retaliating against the employer for something that they did when all they were trying to do is speak up and say, hey, I think this is illegal or this isn't right. This one right here is a big one. Harassment is a harassment. We will have to have an entire separate conversation about harassment. We've got trainings in our platform that are anywhere from an hour to 2 hours long for leaders, supervisors, all the way down to staff, as well as how to handle harassment. It is a big topic, but the simple version is that there are many ways in a workplace where harassment can occur. And anytime harassment is based on just sort of protected groups or characteristics, discriminatory harassment, that's often pretty obvious. But harassment can be situations where people feel unsafe coming to work. They feel like the workplace is just hostile and toxic and bad, and they're very uncomfortable. And that's really the behavior of their peers or their leader that create that environment. And those claims can get brought as well. So what's fascinating about these three claims is that even though there are some requirements over here that touch on these three types of lawsuits, discrimination, retaliation, and harassment, there are some requirements by the federal government and most state governments that there's policies in place that your employees read and understand that talk about the fact that you don't tolerate discrimination or harassment or retaliation at work. And there are some protections in place. But the moment it goes to court, those courts are looking at other things. They're looking at whether or not you did training, whether or not it's required. They're looking at things like, did you survey your employees? Do you have a sense or a pulse on what's going on within your organization? Do you have meetings with your employees? Do you meet with leaders? Do you have these business processes in place that would help you detect and prevent discrimination, retaliation, and harassment? Are you training the people that interview and or handle recruiting within your business? Are you training them on the things that they're not allowed to ask about in an interview with a candidate? Are you giving them a list of the questions that they're allowed to ask or not allowed to ask? None of these things are required. None of these things in the code, regs, or agency guidance are laid out and said, you must do this as a business. But these are all things that courts are looking at when they decide whether or not you're guilty of what you've been accused of as a business. And these optional things make up a very large list. In fact, in the checklist that we've got in HR Law Made Easy, I know because I met with the research team, we often have somewhere between the mid 100s all the way up to 200 unique required things and stuff, right? And these are, again, policy. A lot of it's policies, procedures, documents, agreements, so forth. So depending on the state, depending on the number of states you're in, that list can be really long in terms of like, hey, here's the checklist of things that you need to do to follow these laws that are out there. Now, adjacent to that, we have optional checklists. And these are these types of things. Like, yes, we know that you're in Florida, for example, there's no requirement to do discrimination training or anti-discrimination training. But if you're wanting to protect your workplace from discrimination, retaliation, or harassment claims, this is a great way to do an activity that if you do end up in court, it's less likely that the judge is going to throw the book at you and say, hey, you're guilty. It's more likely that they're going to look at the extra things that you've done and say, this workplace did everything they could to prevent this, assuming that there's not like actual evidence that you did this thing. And it's going to really provide a set of facts and circumstances that help protect you as a company. And that list in most states is hundreds of items long. The optional things that are available to a business to protect them from lawsuits is massive. And they are optional things. These aren't things you have to do, but they're really smart things to look at and to evaluate, especially as we look at some of these lawsuits that are out there. So we've touched on discrimination, retaliation, and harassment. Let's talk about some of the more common claims that come up. Wage claims, for example. You have an employee, you may fire them, you may not. They bring a lawsuit and they're bringing a wage claim, which is just simply like, I don't feel like I was paid fairly, or I don't feel like I was compensated correctly, if you will. And there are lots of things that go into this. It could be that we didn't pay people overtime like we were supposed to. It could be that we had somebody on salary and they really should have been hourly. There's lots of detailed rules behind that do tie into the required stuff. But when we look at wage claims and some of the things that courts are looking at to evaluate whether or not a business is doing the right thing or the fair thing by their people, pay reviews is one of the top things that gets talked about in court cases. Do you have a process in place within your organization where you're looking at all of your people, you're looking at their job descriptions, you're looking at the tasks that they do, and you're looking also at the marketplace and asking the question, am I paying my people fairly? Are the people that work at my company being paid fairly for the job that they've been hired to do? And these pay reviews, which we recommend are done annually as an optional task, right? These pay reviews provide evidence that your workplace looked at everybody's pay, looked at what they did a fair analysis of what others pay similar jobs with similar tasks, and that obviously that those numbers are aligned, and that there's some evidence there that this was something that you paid attention to. And again, this is an optional thing. This isn't required, but it's great evidence to reduce the likelihood that a wage claim can be brought, assuming that you didn't actually break the law, meaning that you didn't actually pay somebody incorrectly or that you didn't ignore overtime, so forth, so on. It's a great way to actually just establish that you as an organization pay attention to pay and that it's something that you really care about it being fair. Let's talk about wrongful termination. This is, again, one of the more common claims and or lawsuits that are brought. And a lot of times what will happen is if I come in and I sue a company or an employee sues a company and they claim discrimination, they'll probably also claim wrongful termination. A lot of times wrongful termination gets attached to other claims. And it just simply, I was fired and I shouldn't have been. Like it was wrong that they fired me. It's all in the name, right? Wrongful termination. So wrongful termination is really interesting because what often happens when we let somebody go, and it's a common mistake by HR, by leaders, is in an effort to try to explain to the person why we let them go, we will say things like, we've got to let you go. And the person will say, well, how come? And you'll say things like, you just didn't do a great job, or you weren't really performing, or you really weren't meeting our standards, or some communication that tells the person there was something they didn't do in their job that they were supposed to do. And often that's why people are terminated, right? Often the reason we let somebody go is because they're just not performing. They're not doing a great job. And we know that, or the supervisor knows that, or we meet internally, and maybe we've even got evidence of that. We've got proof that they're not showing up to work. They're not doing these things. But by communicating to the person that we're letting you go because you weren't doing your job, you're opening the door for their lawyer to ask the first question that's asked when they go to their lawyer. Did you get a job description? And job descriptions are one of these things that every company wants to make the time to do, but they don't often have the time to do it. The reason job descriptions are so critically important in wrongful termination cases is that if a person was given a job description and it was crystal clear about what their duties and responsibilities were, and they were let go because of a failure to do the duties and responsibilities in the job description, you've got evidence or proof, assuming that the employee saw the job description, so I'm kind of assuming that. You have evidence or proof that the employee knew what they were supposed to do, it was written down and they understood it, and they failed to do those things, and that's why you let them go. And that makes wrongful termination go away. Or it makes it less likely that they're going to succeed in bringing a claim for wrongful termination. So job descriptions are one of these optional things. None of the codes, regs, or agency guidance require job descriptions. It's not in the required list. It's in the optional list. Lastly, this is a lawsuit that a lot of folks don't pay attention to because fortunately it's not very common, but it is a really important lawsuit to talk about. And that's negligent hiring. So negligent hiring is where you as a business hire somebody and they have a background of having done bad things. It could be that in a prior job they discriminated or they retaliated or they harassed or they sexually harassed. Maybe they physically attacked somebody in a previous job. And we hire that person, but we don't ask the right questions in an interview. We don't do background checks. We don't call and actually talk to their prior employer in order to get a reference. And a failure to do these things can open the door to negligent hiring. Now, negligent hiring, it's a terrible lawsuit because it means that something really bad has happened. It means that you've hired somebody and that person has come into your organization and has done something bad to coworkers or has done something bad to your customers. And whatever that bad thing is they've done, whether they've harassed someone, they've physically attacked someone, they've harmed someone, the courts ask, did you do the background checks, the due diligence? Did you actually do all the things that you could have done to detect and prevent someone like that from coming into your workplace and doing those bad things in your company to coworkers and or customers? These lawsuits are bad. The settlements float around $1 million. I mean, these are really awful lawsuits. But all that said, doing those background checks, because I mentioned some of these things as I was talking about negligent hiring, doing the background checks, asking the right questions in an interview, calling the places where they previously worked and actually talking to somebody and getting a reference. These are the types of things that courts look at to determine whether or not you did all the homework or did all the work you were supposed to do to try to prevent bringing a bad person or a person that did something bad into your organization. And again, not legally required. In fact, some states like Florida have got a set of 5 things, I think it's 4 or 5 things that you can do, which includes background checks, the right questions in interviews, calling references and so forth. There's a couple other things. And if you do those things in Florida, there's actually a presumption of innocence in the area for this lawsuit of negligent hiring. So there's ways to protect your organization by doing these optional things that are not required by the laws, but that we've learned by reading the court cases. So when we went out and grabbed all the codes and regs and agency guidance, and then we created the lists of the things that were required to do, the checklists within HR Law Made Easy, we knew that we had part of the puzzle solved, right? But what we then did is we really jumped in and dove into these cases and looked at what are the things that the courts are looking at? What are the patterns? What are the themes? What's the evidence that they're looking at to make decisions based on these lawsuits? Because candidly, at the end of the day, there's 2 main consequences for not following the HR laws. One, well, there's more than that, really. I guess I could say there's 3. There's 3 main consequences for not following the law. The first consequence is that your people now work in an environment where bad things are happening. And that means that turnover is likely to go up, your reputation is likely to be harmed, and just bad things in general. And your people, obviously, if you're not already aware of this, are your most valuable asset. So by not following the laws, by not doing these optional things, you really run the risk of harming your people and your organization in a very big way. Now, adjacent to that, which I'd say that's the most important reason to focus on all this stuff, is that you really want to take care of your people. But adjacent to that, by not following the required things and stuff, you open your organization up to court cases, lawsuits, and also government fines and penalties and government investigations. Because there are departments of labor, there are other departments at a federal and state level that if complaints come up, they will come in and they will investigate and you'll have to pay fines and other bad things. And it's also just really bad because all that's public. All that goes online and people can search that and look for the companies that have violated these things. And then lastly, of course, is the court cases and all of the lawsuits that can come here by just not doing those optional things. Because we didn't do these additional things that we could have done, all of these lawsuits can come to the table. And this is where the money is. In other words, this is where companies that experience these types of lawsuits are like, what the heck? Because they're typically anywhere from 20, at the super low end, if you're lucky, $20,000 all the way up to over $1 million for a single lawsuit. And that's often if you settle the lawsuit. The average settlement on a lawsuit in the United States is right around $100,000, which does not include your attorney's fees. So it's kind of a big deal if your company gets sued or somebody goes to a lawyer and then approaches your company. And the ways to protect your company, first and foremost, is to make sure that you're doing the required things and stuff. Because no court and no judge and no lawyer is going to look favorably, look kindly on your company if you're not doing the things that you're legally required to do. And in fact, it tells a really bad story if you end up in court. It tells a really bad story if that lawyer reaches out to your lawyer and says, hey, thanks for the employee file. I've reviewed the information that you provided to the employee, and you're missing, an agreement, you're missing a document, and you're missing 3 policies. In other words, you're breaking the law. And those laws were laid out here, and you're not following them. So as a result of that, we want you to write a check for $50,000 or $75,000 or $100,000. So following the laws is absolutely the first step. The second step is for those organizations that really want to shrink down the risk of lawsuits, that really want to make it less likely that you will successfully be sued. And when I say that, what I mean is that if you're an organization that doesn't actually discriminate, if you're an organization that does not retaliate, you don't harass, you don't actually do these things. You didn't wrongfully terminate somebody. You terminated them because they didn't do their job. You paid people fairly. You followed all the rules. You did all the background check. If you're a company that does the right thing here, then looking at these optional additional steps in order to protect you from claims is really an important part of HR compliance. It goes a little bit beyond the definition of HR compliance because HR compliance is all about following the law. And in this case, we're talking about things that are not legally required. But what it does is it really puts your organization in a position where if you are sued, it's less likely that you're going to have to write a check to somebody because you've done these extra things to protect your people and really make sure that these things are not happening in your organization. So again, just to recap, there's over 1.5 million labor laws or employment laws in the US. They loosely, and I'm high level, I'm making this simple for non-lawyers. They loosely break into 4 buckets. You have codes, regulations, agency guidance, and court cases. The codes, regs, regulations, agency guidance provide the list of required things, and those are here. For the lawyers out there, yes, there are some court cases that have created some rules that have to be followed. I'm just keeping this very simple. For the most part, it's these 3 types of law that lay out the required policies, procedures, documents, agreements, notices, and posters and training that your organization needs to do based on where you have employees. That will help protect your organization. And it's also the right thing to do because it's legally required. And candidly, you don't want to be a lawbreaker. That's just not a good fact pattern for you as a business out in the world. Now, adjacent to that, understanding the types of court cases that are brought and really having a complete list of those cases, all of the different types of cases that can be brought, the things that courts look at, the things that courts are evaluating as they're deciding whether or not to side with the employee that you let go or to side with you as a business. These things, optional things like training or surveys or pay reviews, job descriptions, background checks, calling somebody, the types of things that you ask in an interview, whether you've trained your people on how to correctly interview and the questions to ask, whether you've trained your people on how to let people go. All of these optional things are the types of things that courts will look at in court cases to determine whether or not you've got to cut a check or write a check for these lawsuits. So as you look at compliance, as you look at protecting your organization, the people within it, definitely you want to do the first step. You absolutely want to follow the law. Not following the law is just bad fact pattern for you as an organization. But these optional things are very, very much worth looking at as well. And I know the checklists that we've got cover both in a very comprehensive way. So hopefully this information was helpful. I know we get questions all the time about why is it that this employee is suing us like we did all the right things over here? And why is it that their attorney is still so aggressive? Well, it's because the attorney realizes that all of these other things that could have been done weren't done, and they feel like they can make a case against you as an employer that you didn't do these extra things that they know that these courts are looking at in these court cases. So hopefully that better explains or breaks down the required stuff and the optional stuff and how you can do both to protect your organization. Thanks for being here.